Good evening, everyone. I'm Colleen Murphy, a professor in the law school here at Illinois, as well as with appointments in philosophy and political science, and I direct the Women and Gender in Global Perspectives program here on campus. As we bring the 2019 Congress to a close, it's appropriate that we take one final big picture look at sustainability justice and why it is so important. Our closing keynote will tie together human rights and the environment. And who better to present this than John Knox, one of the world's foremost experts at the intersection of human rights law and international environmental law. He is the Henry C. Lauerman Professor of International Law at Wake Forest University. In 2012, the United Nations Human Rights Council appointed Professor Knox as the first UN independent expert on human rights and the environment. And in 2015, it renewed the mandate and changed his title to Special Rapporteur. In his final report to the Council in 2018, he presented framework principles on human rights and the environment, summarizing the human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment. And in that report, he called on the United Nations to recognize, for the first time, the human right to a healthy environment. He's here today to give a talk named exactly that. And we at the College of Law, the Women and Gender in Global Perspectives program, and iSEE are pleased to have him here as our guest. He'll be speaking, and then following his talk, we'll have some time for questions and answers. There'll be microphones on either side, so raise your hand if you have a question, and we'll be sure to find you. But before that, please join me in welcoming John Knox.
So thank you all very much. Thank you to the organizers for inviting me. I've really found this whole conference fascinating. It's a lot of the conferences I go to are predominantly lawyers and law professors, and so it's been really a nice change of pace for me to be around a bunch of social scientists and other non-lawyers talking about your work. So I personally have found it very, very thought-provoking and valuable. I also just want to thank you all individually for still being here this late in the evening. I encourage you to make yourselves comfortable. If you feel like you need to relax, if you get tired, the floor is available, there are drinks. I mean, really, this is kind of the, the nightclub portion of the evening, I think. So yeah, exactly. Please, let it out. All right, so I'm here to talk about the human right to a healthy environment. And obviously, since I am a lawyer and a law professor, I am going to speak about things from more of a legal perspective, and specifically an international legal perspective. But I think you'll find that many of the things I'm talking about are actually reflecting the exact same issues and many of the findings that the earlier speakers talked about. I won't always try and stop and point that out, but I think it will become clear as I go through what I mean. So let me kind of break up my talk into three parts. I'm going to analyze or try and answer each of these questions. First, does international law and does domestic law already recognize a human right to a healthy environment? And if so, what does it look like? Second, how do other international human rights, such as the rights to life and health, how do they address environmental issues? And then finally, spoiler alert, the United Nations does not recognize an international human right to the environment. So the third question is, should the United Nations recognize the right to a healthy environment? And what would that add to human rights law relating to the environment already? So let me kind of go through this one at a time. So does the human right to a healthy environment exist? Yes, but also no. It really depends on what level of legal organization we're talking about. So when we talk about international human rights law, it's customary to start with the Universal Declaration of Human Rights that was adopted by the General Assembly in 1948. Obviously, we could go back farther than that, but that's a nice kind of starting off point. The Universal Declaration was drafted by the Human Rights Commission that was chaired by Eleanor Roosevelt. Here she is looking at their work. The Universal Declaration of Human Rights includes both rights that Americans, U.S. nationals, are more likely to think of as real human rights, that is civil and political rights, such as rights to life, liberty, security of person, and the other rights in the left-hand column. There are other rights as well in the Universal Declaration in that column, but just to give you an example. But it also includes what the international community calls economic, social, and cultural rights. That is, rights such as rights to Social Security, equal pay for equal work, rights to education, rights to health, and so forth. This is the Universal Declaration as a word cloud. What it does not include is any reference to the environment, nor do the covenants on civil and political rights and on economic, social, and cultural rights that were adopted in 1966 by the General Assembly after 18 more years of negotiation. They also don't refer to the environment. This is the ICCPR, the Covenant on Civil and Political Rights Ratification Map. As you can see, most countries in the world, the dark green indicates countries that have ratified the covenant. Most countries in the world have. The major exception is China. The ICE SCR, the Covenant on Economic, Social, and Cultural Rights, has also been ratified by most countries in the world, the major exception being the United States. China has signed but not ratified the ICCPR. The US has signed but not ratified the ICE SCR. But the point, as far as we're currently concerned, is that neither of those covenants, again, includes a human right to a healthy environment. This is not really because Eleanor Roosevelt just forgot and the other drafters that it was just not on their agenda. The modern environmental movement, and I realize we can have a lot of discussion about when the environmental movement began too, but in terms of its influence at the United Nations, the modern environmental movement just came along after the foundational human rights instruments have been adopted. 1969, 70, 71 saw the first real attention at the United Nations to environmental issues, but by that time the major human rights instruments, the so-called International Bill of Rights, the Universal Declaration, the two covenants, had already been adopted. The story was very different at the national level. At the national level, beginning in the 1970s, now, and continuing to the present, 100 countries have adopted in their national constitutions some form of a right to a healthy environment. 2/3 of the constitutions actually specifically refer to the word health. Others refer to an ecologically balanced environment or a clean, safe, wholesome, satisfactory environment, and so forth. But the point is, at the national level, the right to a healthy environment is pretty widely accepted by most countries in the world. Even more belong to regional human rights treaties. Most regions in the world have a regional human rights treaty. There's the American Convention on Human Rights that covers the Western Hemisphere. There's the European Convention that covers Europe. There's the African Charter, and so forth. All of them, with only a few exceptions, they do include some version, again, of a right to a healthy environment. So when you put the national constitutions and the regional treaties together, you get a map that looks like this. This is most of the countries in the world have accepted this right. Again, with some major exceptions, the United States, Canada, Australia, and China and Japan have still not accepted it at either place. The closest the United Nations came to accepting the idea of a right to a healthy environment was in 1972 at the first Stockholm Conference. The only Stockholm Conference, the first major conference on international environmental issues. This was Principle 1. Man, it's gender biased, obviously, according to the prevailing norms of the time, but in any event, man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being. That's pretty close to saying that people have a right to a healthy environment. It doesn't quite come out and say it, but it's pretty close. 20 years later, though, in the Rio Declaration, adopted as part of the Rio Conference of 1992, this language appears instead. Human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. Entitled to sounds a lot like they have a right to, but of course it doesn't really mean the same thing. The idea of a right has historical and legal, let's say, consequences that simply saying that people are entitled to something doesn't have. And that, of course, was intentional. They wanted to avoid saying that there's such a thing as a human right to a healthy environment. That was on the environmental side of things. And the human rights side of things, the Human Rights Commission, the same body that once upon a time had drafted the Universal Declaration and the Covenants, in 1994 was presented with a report from an independent expert named Fatima Centini who proposed that the United Nations Human Rights Commission adopt a declaration recognizing the right to a healthy environment. That also was shot down. The Human Rights Commission refused to act on that request. And so so there's this huge dichotomy, there's this division. At the United Nations level, there's just silence on the idea of a human right to a healthy environment. But the national level and the regional level, there are all of these expressions of the right. All right, so the second question. What about other human rights? What do they say about the environment, or how have they been applied in the environmental context? And this is, I think, where the story gets really interesting, because other human rights have been applied to environmental issues now increasingly for the last 25 years. Human rights bodies have greened human rights, for want of a better term. These include the European Court of Human Rights, which operates at its headquarters out of that kind of spaceship-looking building on the left. That's what, when Elon Musk takes the European elites off to Mars, it's going from there. The building on the lower left is the Inter-American Court of Human Rights building in Costa Rica. And then these are pictures of United Nations special rapporteurs. Special rapporteurs are individuals, independent experts appointed by the United Nations Human Rights Council, the successor body to the Commission, to essentially investigate, oversee, issue reports on human rights compliance by states. And what's interesting is that increasingly these bodies, the regional tribunals and the independent UN experts, began to apply human rights such as rights to life, health, property, and so forth to environmental issues. So I'd like to just quickly go through a few of the cases that kind of illustrate the kinds of claims that were being brought and how they were reviewed. So this is perhaps one of the most famous. SERAC v. Nigeria, the African Commission decision from 2001, arose from the vast pollution in the Niger Delta arising from 40 years of exploitation by Royal Dutch Shell and the Nigerian government. When the UN Environment Program later did a study of just how bad the environmental harm was, they found things like that there was oil pollution 5 meters deep in the soil, 15 feet. There were levels of dioxin thousands of times, levels of dioxin in well thousands of times above WHO limits, and so forth. So essentially, the Nigerian Delta, where these wells were located, had been polluted as badly as any area in the world has ever been polluted. Starting in the 1990s, in particular in the 1990s, although there had been opposition before that, but in the 1990s, the Ogoni people, the people who lived in this Nigerian Delta region, engaged in a series of peaceful protests, which were met by crackdowns and arrests. The Nigerian government ended up executing the 9 leaders of the Ogoni people. They destroyed villages and crops. It was severe repression. So the SERAC, a nonprofit organization, brought a claim to the African Commission. The African Commission does not have binding legal authority, but it does have the ability to review claims of violation of the African Charter. Now, obviously, a lot of the things I've just described are absolutely clear human rights violations. There's just no doubt about it, you know. But the interesting thing about this case was it went beyond just saying kind of what human rights lawyers would say is obvious. If you arrest people and execute them for no reason and you destroy their villages, obviously you violate their human rights. It went beyond that by saying that the failure of Nigeria to adequately regulate and protect the environment of the Niger Delta also was a violation of human rights. The African Charter, as I said earlier, does include a right to a healthy, they call it in the Charter, a satisfactory environment. But the Commission went beyond that and used other rights as well, specifically the right to health. And on that basis, it said that states have an obligation, Nigeria and other states have an obligation to basically take all reasonable measures to protect human rights from environmental harm. They also got a little bit more specific and said, among other things, that means that the state should do things like have prior environmental impact assessment. They should make sure that benefits from the exploitation go to the people who are most directly affected and that those people have information about the harm that's affecting them. Let's go to Europe. 3 years later. By this time, the European Court of Human Rights actually had a whole series of decisions. They had really started around 1994. But in this one, I think it's kind of an interesting illustration of the way that the law has been developing in the European Court. Öneryildiz v. Turkey involved an explosion at a garbage dump, a rubbish tip, in a suburb of Istanbul. The rubbish tip was not adequately regulated. There had been strong warnings that it was in danger of exploding because of methane buildup. Not only that, people were being allowed to live right around the rubbish tip. So when it exploded, it killed over 24 people and destroyed a larger number of their homes and injured more as well. The Turkish government actually investigated this and prosecuted the mayors of Istanbul and the suburb in which the rubbish tip was located, but it gave them kind of just a slap on the wrist, just a fine, no prison time, despite the fact that it found that they had ignored warnings about the potential harm. So the European court said that's not enough. Under the European Convention, everyone has the right to life. Governments have an obligation to protect the right to life against foreseeable threats. The Turkish government hasn't done that. And not only did it ignore the warnings, it also should have done more to investigate and punish those responsible. We've talked a lot about, or heard a lot about, indigenous people's rights in the course of the last couple of days. The Inter-American Court has issued a series of cases defining and clarifying indigenous rights in the inter-American context. This is a particularly important case for a couple of reasons. The Saramaka people v. Suriname case was decided by the court in 2007. It involved mining and logging exploitation of forests occupied by the Saramaka people. One of the reasons the case is important is that the Saramaka people are not actually indigenous in at least one sense of that word, in that they're Afro-descendants, Maroons who were brought as enslaved people to the New World and then essentially escaped and reformed tribal communities. So one of the important things about this decision is that the court said they have to also be treated as having the same kinds of rights as indigenous peoples because they have the same kind of relationship with the forests and the natural ecosystems. They're similarly closely dependent on and intertwined with them culturally and materially. So what are those rights and what obligations did the court say that the Suriname has? Suriname has, among other things, obligations to delineate the territory that's been the traditional territory of the Saramaka people, to consult with them before they allow any concessions in that area that include the use of the territory or natural resources on the territory, to do environmental impact assessment, to make sure that they have the benefits of any kind of exploitation of the land, but also in case of if there are going to be any major effects, the Saramaka people have the right of free, prior, and informed consent. That means they can say no. This is, I should make clear, the idea of FPIC, or free, prior, and informed consent, is expressed in the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP. But many states don't regard UNDRIP as legally binding on them. So for the court to say that this is legally binding on the basis of the American Convention on Human Rights, which is a legally binding human rights treaty, was a really big deal. Here's another case on a topic we've talked about or heard people talk about over the last couple of days. Mossville Environmental Action versus the United States also went to the inter-American system and resulted in a commission decision in 2010. Mossville is pretty famous, so some of you may well already know about it, quite a bit about it, and in fact may know more than I do about it. But Mossville is a predominantly African-American community in Cancer Alley in Louisiana. Maybe 400 or 500 people live there. It's a very small community. It is of the parish in Louisiana that Mossville is part of. In that parish, there are 27 major chemical plants, oil refineries, or other sources of toxic, 27 in the parish as a whole. Mossville has 14 of them in or around it. Mossville has about 1% of the total population of the parish. It has more than half of all the toxic waste sources. So the Inter-American Commission, this is a little map just showing some of the sources right around in Mossville. So the Inter-American decision was on admissibility. The United States said, wait a minute, there's no right to a healthy environment in the inter-American human rights system. You should just dismiss this case. And besides, there's no evidence of intentional discrimination here. I mean, it's just kind of how it worked out. Now, we've already heard the various justifications that governments can make as to why something might work out so that, 14 out of 27 toxic sources are all in one little community. But the commission said a couple of important things. Again, first it said, well, again, we don't have to have a right to a healthy environment in our treaty in order to be able to apply other human rights. And second, non-discrimination norms at the international human rights level don't require evidence of intent. If there's disparate impact, if there's discriminatory effects, and the government knows about it and keeps going ahead anyway, that's a violation of rights under non-discrimination principles. And that, of course, is true not only in the inter-American system, but throughout all levels of international human rights law. Mossville, I should make clear, not all these stories have particularly happy endings. I mean, this is building up a kind of body of international law, but I don't want to suggest in any way that it's completely effective, because that's just not true. Mossville was an admissibility decision, which simply means the commission decided it had jurisdiction to hear the case. It never issued a decision on the merits. And in fact, Mossville is being pretty much destroyed by, it's being bought out by one of the chemical companies, Sasol, a South African chemical company, has for the last 5 years or so simply been buying out Mossville kind of one house at a time. Nevertheless, the idea that international bodies can provide a kind of different frame of reference, that they can look at discrimination in ways beyond just what US courts can look at or what other countries' courts can look at, is a very powerful one, I think. You've seen a lot better charts than this earlier today, but I'll show you this one anyway, just because it's another illustration of the ways in which environmental racism can increasingly be identified. In the 90s, a lot of the focus was on, as is the case in Mossville, on deciding where the sites would be for various kinds of environmentally harmful actions. But increasingly, we're able to do, and again, the earlier panel talked about this in much more detail, but now we are able to figure out not only that there can be environmentally discriminatory siting of facilities, but also that pollution from those facilities has environmentally discriminatory effects. So, you know, again, international norms, I think, apply to this in some ways much more easily than domestic norms do. Okay, so there's this greening process of human rights law, these decisions kind of percolating up from all of these different sources. So in 2012, the United Nations Human Rights Council returns to this issue. This, by the way, is where the Human Rights Council meets in the Palais des Nations in Geneva. The old League of Nations building is now part of the United Nations, and this is where they meet. This is actually how this ceiling really does look. It looks like it might be about to fall in. It looks like it's a multicolored, what do you call the ones that come down? Stalactites, right? Not stalagmites, or, well, anyway, it's the stalactites, because they hold tight, right? I used to really, so I've spent a lot of time in this room. It used to kind of, I mean, at first it kind of annoyed me. I thought, you know, this seems kind of, I don't know, too frivolous or something for the serious topics we're discussing. But over time, it really grew on me, partly because you spend a lot of time in these conferences listening to government officials kind of drone on and on and on, and it gives you something to occupy your mind. You can look at these stalactites and think, well, if it did fall, not that it ever would, but if it did fall, where would it fall, and would it take out the French delegate who's going on and on? Again, it never happened. I'm just saying that was a way to pass the time. In any event, so in 2012, the Council created a new mandate. As I said, the Council has a number of special rapporteurs. There's special rapporteurs on torture. There's a special rapporteur on the rights of indigenous peoples. There's a special rapporteur on the right to food, and many, many others. But they had never had a special rapporteur on human rights and the environment. In 2012, they didn't exactly create that either. Instead, what they did is create a new mandate for an independent expert on human rights and the environment. What's the difference? The difference is that they decided that the law on human rights relating to the environment still needed to be clarified. And so instead of appointing a rapporteur, someone who would go out and write reports on investigating violations and so forth, instead what they would do is appoint an independent expert with a 3-year mandate to study the human rights obligations and identify best practices in their use. So that's what I was appointed to do. So I spent much of the next 3 years doing a mapping project. I essentially went and, with the help of a lot of research assistants, I looked at every single statement I could find by every human rights body working at the international level on environmental issues and simply wrote reports about all of them. I wanted to make clear that any conclusions I told the Council, any characterizations I made of the law to the Council, I wanted the council to know that I had looked at all the sources. I didn't want there to be any doubt about that later. So I wrote 14 reports, again, with a lot of help, totaling almost 1,000 pages, I think. It really added up. And I reached certain conclusions. I found that, in fact, all of these bodies had dealt with environmental cases. All of them had said that environmental harm could interfere with human rights, a vast range of human rights. And all of them had said that states, therefore, have obligations to protect environmental harm to the enjoyment of human rights. I'll come back in just a moment to those obligations in more detail. I also held a number of consultations around the world. I wanted to hear what people actually working on these issues had to say. I didn't want the research all just to be kind of at the desk level. And so I had consultations in lots of different places around the world. I talked to, I don't know, hundreds of people over this time. And one of the things that really struck me was wherever I went, what people wanted to talk about, in every single one of these consultations, what people wanted to talk about was the threats that environmental defenders were facing in their region. So I would have topics for the consultation. This is a consultation about procedural obligations, or this is a consultation about the rights of minorities and indigenous peoples, or whatever. And we would talk about that. But we would also find ourselves talking about the killings, the harassment, the arrests, the just general difficulties that environmental defenders were having simply in going about their work. And so that became one of the focuses of my mandate. And of other mandates as well. There's a special rapporteur on human rights defenders, Michel Forst, and he wrote a report on environmental human rights defenders a couple of years later. He describes environmental defenders as individuals and groups who strive to protect and promote human rights relating to the environment. The thing about environmental defenders is they often don't know they're environmental human rights defenders, because this connection between the environment and human rights is not always one that environmental groups or local communities or indigenous peoples always kind of are able, that they know they can make the connection in terms of international human rights law. They're just trying to deal with the problem in front of them. But the fact is as far as international human rights law is concerned, they are human rights defenders as well as environmental defenders. So some of them, of course, are quite famous. Chico Mendes, who was killed in 1988 in Brazil, rubber tapper, he's still, his name still is one to conjure with all of these years later. Ken Saro-Wiwa in Nigeria was one of the leaders of the Ogoni people who was executed unjustly by the Nigerian government in 1995. But many, of course, are not. Bianca Jeanette Cawas Fernandez in Honduras was just working to try and help conserve one particular forest in Honduras. She was killed because of complicity between the Honduran government and local developers. The interesting thing about her, though, is that her case ended up going to the Inter-American Commission, again, the Inter-American system. And eventually the Inter-American Court of Human Rights issued this decision saying states have obligations with respect to the protection of environmental human rights defenders. They have obligations to protect them from threats and harm, but also to refrain from placing restrictions on the performance of their work and to conduct serious and effective investigations of threats or harm against them. Obviously, Honduras did none of those things in that case, and neither do a vast majority of other governments. So you've already heard a couple of times about the Global Witness reports. Let me spend a couple of minutes talking about them. Global Witness, as a result of the killing of a colleague of theirs in Cambodia, Chut Wadi, decided that this was an understudied problem by the human rights community. And so Global Witness, which is based in London, but which operates in many countries around the world, went back 12 years. They wanted to see just how bad this problem was. What they found is over a 12-year period, they could document 908 killings of environmental defenders because of their work. I really encourage you to read their reports. They're very careful. You could even say conservative, as they would admit themselves. They only include killings if it's clear that the people were killed because of their work. So this is an understatement of the total number of deaths, because if it's not reported, that they're not including it. The deaths are in many different countries around the world, but they're particularly bad in Latin America and Southeast Asia. Global Witness since then has issued a report every year. The number of killings has gone up. 2015 saw 185 killings. 2016 saw 200. That's obviously 4 a week. 2017 saw about the same number. In 2018, it did drop somewhat down to 164, which is still more than 3 a week. This is you saw the quote earlier from Vicky Talley-Corpuz, the Special Rapporteur on Indigenous Peoples' Rights, earlier when she says that basically an environmental defender is killed every 2 days somewhere in the world. This is the number she's talking about. Again, I want to emphasize these are low numbers. Almost certainly the number is far higher than this because, I mean, to go back to the map, I mean, much of Africa, for example, is just white space. That's not to say that you're in great shape. If you're an environmental defender in Sierra Leone or Ghana or the DRC, it just means we may not know what threats you're facing in those countries. I should also say that one of these maps in particular identifies the number of indigenous people that are killed. Indigenous people are, as we've heard, on the front lines of protection of the environment, on the front lines of protection against the ravaging of the natural world. And so a disproportionate number of these deaths are of indigenous people. Berta Cáceres, I always feel like I don't want to just give you the numbers, right? Because each of these numbers represents an individual. Berta Cáceres, I think, got more attention than most of these deaths got. She was actually the Goldman Prize winner at the time. The Goldman Prize, if you don't know, is kind of, I don't know, like the Nobel Prize for grassroots environmental activists. The lunchtime speaker today was a Goldman Prize winner for the United States. The Goldman Prize gives out 1 award a year to each region of the world. Berta Cáceres was the Goldman Prize, the reigning Goldman Prize winner when she was shot, which just indicates that that fame and knowledge about your work in the international community was certainly no guarantee of safety. I also want to emphasize that the number of killings is only kind of the tip of the iceberg when we think about all of the people whose lives are affected by harassment because of their work on environmental issues. I'm just going to just mention one of the tens of thousands of people in this category. Going by the blogger nicknamed Mother Mushroom, this Vietnamese woman was arrested by Vietnam in 2016 for propaganda against the state. Her crime, she had blogged about a major spill from a chemical plant going into waters off the coast of Vietnam that killed fish and put fishermen out of work and devastated the fishing communities in the area. She just said, this is a problem, and maybe the government should do something about it. What they did about it was arrest her and sentence her to a term in prison. They released her a year ago after she had served 2 years in prison, but obviously many people are not released. Again, there was a fair amount of international pressure on Vietnam to do something about it, but for many people, they just don't get that kind of attention. We could talk a lot more about this. Just briefly, let me just say, I think the reasons for this are fairly obvious, right? Let me be non-social sciencey here and just make it at a very general level. Governments and corporations are doing their best to exploit the natural environment. The people who are most affected by that exploitation are also usually, if not always, marginalized in the legal systems and power structures in their countries. And in those countries, there's often a lack of rule of law. You put those ingredients together, you're going to have these results. It's a simple recipe. What do I mean by absence of the rule of law? This is from the first Global Witness report, the one that went back 12 years. Of those 908 killings, they broke down how many they could find where the perpetrators were even identified. And then of those, how many were arrested, and then of those, how many actually did time. The bottom number is the column in which the killers were tried, convicted, and punished. They found 6 out of 908. That's utter, complete impunity. You kill someone, there's a 99% chance you're going to completely get away with it. Even for those 6, I imagine that the people who paid them didn't get caught. Okay, so I did a fair amount of work on that as a special rapporteur. I want to emphasize a lot of people are working on this issue around the world. I think it's gotten a lot more attention by environmental and human rights groups than it used to have 10 or 15 years ago, although it's been a problem for a really long time. So now we're up to 2015. in 2015, the Council renewed the mandate for another 3 years. They changed the title to Special Rapporteur. They said, yeah, okay, apparently the norms are clear enough that you can actually go out and promote their realization and identify obstacles. The Council doesn't like to use the word violations or anything like that. So this was fine, though. This enabled me to do what other Special Rapporteurs do, which is receive communications, go on country visits, and generally try and promote compliance with these norms. At the same time, I issued reports trying to continue to clarify the norms in specific areas. I issued reports on climate change, for example, and biodiversity and children's rights. One thing I did was issue these guiding principles on human rights and the environment. What these framework principles, I should say. These framework principles, the idea is simply that they summarize what human rights bodies have said about human rights and the environment in a kind of easily digestible form. This is not what UN reports usually look like. I had a human rights group volunteer to essentially put it into a nice looking format with pictures and everything, which I appreciated. It turns out not everyone reads UN reports. They should. I don't know why they don't. But in any event, so just really briefly then, the first two principles just express what I think is kind of the fundamental interdependence of human rights and the environment. You have to have a healthy environment in order to be able to enjoy a vast range of human rights, but you also have to be able to exercise your human rights in order to be able to effectively protect the environment. There's just no getting around either one of the halves of that circle. So, human rights bodies, what have they said? They have identified a number of procedural obligations, one being, of course, you have to protect environmental defenders, but also you have to protect more generally freedom of expression and association in the environmental context. You have to promote education and public awareness of environmental issues, information, impacts, public participation, access to effective remedies. All of these have been identified by human rights bodies as necessary to protect rights, human rights to life, health, food, water, housing, and so forth. Substantive obligations, human rights bodies are more, let's say, deferential to governments on. They don't want to, I think there's a couple of reasons for this. One is the perfectly valid one, that they don't really think that it's fair to hold Ghana, say, to the same environmental standards as Germany at a substantive level. There's also a feeling among many human rights bodies that they don't really know what the right substantive standards are. In other words, like what level of dioxin or sulfur dioxide is really acceptable. That's starting to change over time. Human rights bodies are becoming more assertive on this, and they're doing it by applying factors. They're saying, well, in order for us to say that your substantive standard is okay, we have to be sure that it's non-discriminatory, that it's progressive, it's not going backwards, but also, have you taken into account, like WHO international standards on what a safe level of pollution is in this area? And at the end of the day, is the balance you say you're striking between environmental protection and whatever else you're doing, is it actually a reasonable balance, or is it like the Niger Delta, where clearly by no reasonable account could anyone say that's somehow a reasonable balance between your desire for economic development and environmental protection? Finally, then, once you have these standards, human rights doctrine says you got to enforce them. It's one thing to say we're going to give you some discretion in setting your own standards based on your own societal goals, but you have to actually enforce them then. What about transboundary and global harm? This is a bigger conversation than we kind of have time for now, but just briefly, I emphasize that there is an obligation of international cooperation to deal with issues such as climate change and global loss of biodiversity. I wrote reports about that. I'm happy to talk about that more. But for now, let me just kind of leave it at that. And then finally, a number of the framework principles address those who are most at risk or most vulnerable or in situations of vulnerability. Obviously, there's an obligation of non-discrimination. But in addition, states have obligations to take additional steps to protect women, children, the elderly, the disabled, and everyone else who is at increased risk of harm to their human rights from environmental degradation. Indigenous peoples actually have their human rights defined more clearly than almost any other group in or population in human rights law, both as a result of the UN Declaration on the Rights of Indigenous Peoples, International Labor Convention 169, the work of special rapporteurs. So there's a long list of rights that they have. Again, governments often don't comply with them, but as far as I was concerned, I could draw on that in saying that governments have to protect those in the environmental context, obviously. And then really finally, the very last principle said, governments can't use it as an excuse the idea that they're pursuing sustainable development or any other goal. You often hear governments say things like, well, this dam is going to be great. This is going to be such a great dam, and it's going to be great not only because it's going to make a lot of people rich. No, we're not really concerned about that. It's going to be great because it's renewable energy. Well, renewable energy, that is good. I mean, let's put aside whether dams are the best way to go about it, but the bigger point is, even if you're saying that the purpose is a legitimate one, you can't ignore human rights along the way. You can't, for example, say, well, because the dam is going to have renewable energy, we really, really have to get rid of all the indigenous people that have traditionally lived in this area. And if they disagree, if they fight back, well, we may have to arrest a few and even kill them. Berta Cáceres, by the way, was fighting a huge system of hydroelectric projects in Honduras. And her death has been traced back to government officials as well as the corporations that were going to profit from the dams. So that obviously can't be an excuse. So in 2018, I came to the end of my second 3-year term, and my mandate ended. You can only serve 2 3-year terms. So I was given my farewell watch. Actually, you don't get anything. This isn't, maybe I should have made this clear. I was never a UN employee. To be independent, it also means that you don't get a salary. My wife kept asking me the first year or two, she's like, seriously? There's not even a little something? And it's like, nope, there's really not. And that's actually how it should be in a sense, but it causes obvious problems in getting more representation among social rapporteurs from people who don't have academic jobs in the global north that can support them. That's also an issue we can talk about. But in any event, they renewed the mandate. They appointed another special rapporteur. And then in the new mandate, they asked the special rapporteur to submit an annual report, not only to the Human Rights Council, but also to the General Assembly, which is a pretty major step forward. So cases have continued. Many of you may have heard of the Urgenda versus Netherlands case. This was a decision last October by a Dutch appellate court basically saying that the Netherlands has to take quicker steps to reduce its greenhouse gas emissions, and that it has to do it in order to protect people's right to life and private and family life. In other words, they based it on the European Convention on Human Rights. Huge decision. I talked to lawyers recently who said that there are at least 7 or 8 other cases in Europe following in their Urgenda footsteps in preparation now or already having been filed. Just last month, the Human Rights Committee, yet another organization, the organization that oversees the ICCPR, it's composed of 18 independent experts, it decided the Portillo Cáceres v. Paraguay decision in which it said Paraguay had violated people's rights to life by inadequately regulating pesticide application on gigantic soy farms that had resulted in the death of one person and the illness of many others. And in announcing it, one of the members of the Human Rights Committee said, there are hundreds of other cases like this in the world. Start bringing them to us. People are. This one just was announced 2 days ago. This is a decision by 16 youth from around the world, including the rock star, Greta Thunberg, and it's being brought to the Committee on the Rights of the Child, another treaty body overseeing a human rights body, alleging that these countries, which have all accepted the jurisdiction of the Committee over communications like this, that these countries have all violated human rights by not taking more adequate, more effective steps to deal with climate change. So that's kind of, I realize that's a lot, right? But the second act of the show here is now over, and that's by far the longest, so you have that going for you. But the point is that a lot has happened on human rights and the environment, even in the absence of a globally recognized right to a healthy environment, which raises the question, so should the United Nations recognize the right? To which the answer is yes. I mean, I suppose at this point you'd be kind of surprised if I said no. Like, would you, if I said actually no, you'd all be like, really? Wow, I did not see that. This is a twist, you know? I thought Danny killing everybody was a surprise, but this is right up there. Yes, of course it should. In my last report to the Human Rights Council, I urged them to support recognition of a global human right to a healthy environment. David Boyd, who's my successor as Special Rapporteur, made the same pitch in his very first report to the General Assembly, I should say, last October. The General Assembly has said these are the factors you should take into account deciding whether to have a new human rights instrument. It has to be consistent with existing human rights law. It has to be a fundamental character. It has to be precise enough. It has to provide realistic and effective implementation machinery. It has to attract broad international support. In the interest of time, I'm not going to go through these all one by one, but it just does all those things, right? I mean, that's just kind of obvious at this point. Most countries in the world are completely comfortable with the right. We know what it means because we can draw on the obligations I set out in the framework principles. This is not a case of kind of jumping into the unknown. We know what human rights law can and already does say about the environment, and the United Nations should just recognize that. How could it do it? Well, it could enact a new treaty or adopt a new treaty. The French proposed a couple of years ago a global pact for the environment. That hasn't really gone anywhere, and I don't think a new treaty is really necessary. You could also have a protocol to an existing treaty. I don't really think that's the best idea either. I think the best approach would just be to have the UN General Assembly adopt a declaration saying, yeah, we recognize there's a right to a healthy environment. There's actually a precedent for this. In 2010, the General Assembly did just that for the right to water. We heard yesterday about the idea of a human right to water. I think it's pretty widely accepted now. But it's also, for whatever reason, not included in the fundamental human rights agreements. The General Assembly just said, yeah, okay, well, it should have been. By now we know what it means. Let's just announce that there is one. I think they could do the same thing with the right to a healthy environment. Final question, so what would that add? What would be the point of all this? I actually edited a book where people gave answers to that question. I encourage you to check it out or buy it. It's not that expensive. Go buy it. One thing the right could do is serve as a capstone that kind of integrates the whole body of human rights relating to the environment already. There's a lot of case law out there, as I gave you just a taste of, but it takes a long time to go through it, you're probably thinking to yourself. How much better it would be if we could just say, there's a human right to a healthy environment. People have a sense of what that means. But it could also, some argue, provide as a kind of cornerstone, something that you could use to build on for further development in new directions beyond existing human rights. For example, some would argue that it's time to recognize more formally rights of future generations. We also just kind of briefly touched on the idea of rights of nature. This is the Wanganui River, which a year ago, 2 years ago now, was recognized by the New Zealand government as having legal personhood. Largely on the basis of Maori recognition that the Wanganui River has legal personhood. You could imagine other development, there are a lot of other developments like this taking place at the national level. You could imagine developments like this being recognized in international law as well. I personally think that that is unlikely to be recognized anytime soon by the United Nations, but things can change over time. I do think there's a pretty good chance that the General Assembly will end up recognizing the right to a healthy environment in the next 2 or 3 years. At least that's my hope. That concludes my talk. I'm on Twitter. I only tweet about human rights and the environment, so you don't have to worry about my thoughts on, I don't know, the Kardashians or whatever people tweet about. So if you're interested, there it is. And I'm happy to, you're such a knowledgeable, engaged group. I'm very happy to take any questions or hear any comments you might have about any of this.
So there are 2 microphones. Is there a hand right there?
Yeah, so I suppose this question could apply about any area of human. I suppose this question could apply about any area of human rights law, but it just raises in my mind. Okay, so what happens when these cases are, you made an allusion that these cases all don't all have happy endings, et cetera, et cetera. Just because the court decides something doesn't mean anything happens. What does actually happen? In these cases, what is the point? You said one of the points was building up the case law that could then be used, right? So what are the kind of long-term end games of these kinds of decisions being built up?
Yeah, no, that's a really good question. So, and I should have kind of not left you hanging there on that. So, So part of the answer to that is that there are different levels of effectiveness of different international human rights bodies. So for example, I said the Inter-American Commission and the African Commission do not have the ability to issue binding decisions, but the regional courts do. So the European Court, the Inter-American Court, the African Court all do have the ability to issue binding decisions. Now, again, that doesn't mean that states always comply with them, but many states do comply with them. It's kind of, I mean, that's a whole interesting area of international law and policy. Why do states ever comply with international law? But often, whatever the reason, they do. So the fact that you can have an institution that can hear individual claims of human rights violations and issue at least a normatively and apparently a nominally binding decision in itself is really useful. So these things are used a lot. I mean, one way I always I want to remind people that the people who are most interested in how well these things work are the people that actually have to put in the time to prepare the claims, the local communities, the lawyers representing them, and so forth. They kind of vote with their feet, so to speak. If they put in the time to do it, it must mean that they think there's some value out of it. So I think sometimes legal academics can get a little too cute with this, saying, well, of course there's no real effect. What's the point of all this? I think we need to be careful not to assume that the people doing this simply don't know what they're doing and that they didn't ever figure out that it's, they get to the end and they're like, oh my God, it's not legally binding. They're very sophisticated. They know what they're doing. And so how do they use these things? Even the non-legally binding ones can help in the context of local action. They can help raise awareness of issues. Often they can embarrass the government even if it's not legally binding. There's a famous decision by the Human Rights Committee, which is now, I guess, 15 or so years ago, not about the environment, but about, it was a case it brought against Australia, Tunin v. Australia, in which the issue was whether Tasmania, the last one of Australia's, is it states, provinces? Anyway, it was the last state to make same-sex conduct illegal, same-sex sexual conduct illegal. And the activists who brought that case knew quite well that Australia wasn't going to be legally bound by the decision, but what they were counting on, and which worked, was that Australia would be so embarrassed by the idea there was still a part of Australia that was saying that it was criminal to have homosexual conduct, homosexual relations, that they would put pressure on Tasmania to change the law, and that happened. So I guess, so that's part of the answer. I also want to emphasize that, remember, even though I didn't talk about it very much, a lot of the activity here is going on at the domestic level. And so if you have a constitutional right to a healthy environment, often the courts in that country can draw on the development at the international level. There's a two-way street that goes back and forth. And so that can help as well. One of the things I did was, for example, meet with national human rights institutions in different countries, many of which, again, don't have the ability to make binding decisions, but can influence legislation and raise awareness to issues and so forth. And they, too, are increasingly getting environmental issues brought to them. So there's this kind of percolation of these issues everywhere, and it kind of all helps support each other build up. I have to say, a lot of the focus in the last couple of days here has been here on the United States. It is really hard to see signs of this in the United States, because the United States government does everything it possibly can to build walls against international human rights law kind of seeping in, right? We talked about, Kim told us about seawalls. Imagine a gigantic human rights wall around the United States. Heaven forbid some international human rights norms somehow make it through the wall. That's been the case for a really long time. I don't in any way want to say that that has to be the end of that story or that narrative. I just want to say that's not how it is in a lot of other countries in the world. They just pay more attention to what international human rights mechanisms say. I don't want to, so at the same time, I don't want to overstate it. I don't want to make it sound like it's more effective than it is. Also don't want to make it sound like it's just totally meaningless and the people who are doing this are just kind of like, have nothing better to do with their time, because I think that's just not true either. Sorry.
Hi. Thank you so much for sharing your work. Very interesting. My work is in environmental philosophy, and philosophers, like lawyers, try to be really precise with their language. And one of the things I've been tracking in my work is how difficult it is to define exactly what nature is. And a lot of philosophers have suggested moving to the environment instead, using that word. And I was trying to track earlier in your talk about which treaties mentioned nature and which mentioned the environment, but toward the end you increasingly used a right to access to the environment. I'm wondering if you've encountered any difficulties with, or foresee any difficulties with just defining what is the environment. Access to water, access to air. It seems obvious, but then when you think about it, it's sometimes difficult.
Yeah, that's a really good question. And it was a decision I had to make early on. Was I going to try and define what I meant by the environment? And I just made a conscious decision. What a strange term that is. I guess as opposed to an unconscious decision. But I made a conscious decision that I just wasn't going to. Most of the human rights, most of the instruments that refer to a right of some kind at the national or the international level do refer just to the environment. They don't try and define it. So maybe unlike philosophers, lawyers can kind of leave terms undefined in the hope that over time, judges, communities, lawyers will kind of flesh out what the meaning is over time. I think the development of the term environment over time has been to make it broader, more inclusive, to include more things rather than fewer things, and I think that's very healthy. So I think any definition would run the risk of turning out to be overly narrow and excluding something that later on you would say, gosh, I wish we hadn't left that out, but we didn't anticipate it at the time. So that, I think, is kind of, at least my thinking about why I decided not to try and define it. But you're right, the term usually used in the law is environment more than nature, and I don't have a good answer for you about why that is. Now, you do see nature sometimes, but often at the international level, it's more in older conservation agreements than it is in newer environmental agreements.
I think I'm
Sorry, there's two of you in a line.
Go ahead.
So,
Okay, great. So you happen to be in a state where the Constitution, adopted in 1970, has an article giving the citizens of Illinois a right to a healthful environment. Now, that was interpreted by our Supreme Court in 1999 as being quite limited. Going
Yep.
not expanding, the way you just referred to, and the interpretation did not, or the majority held it didn't include threatened species from a proposed dam. Okay, and the minority, the dissent, made a nice argument about ecosystem health really relating to human health and such, but the majority said, well, clean air, clean water, that was what people were worried about in 1970 for human health. And since the legislature has passed laws in this area, there's no further rights under the Constitution. So I would just urge you that, obviously you're addressing the threshold question of whether there should be any human, environmental right, but more specificity, or at least identifying some areas of nature,
sure.
or species survival and such is critical. And a lot of those national constitutions that you were referring to do go beyond,
Yep.
Just a healthful environment to refer to, some aspects of nature.
Yeah, so that's certainly true. There's a huge variety in how much detail national constitutions get into. As you said, Illinois does have a right to a healthy environment in its constitution. In the early 1970s, there was a movement in a number of U.S. states, including Pennsylvania, Illinois, Hawaii, Montana, maybe at least a couple of others, to include a right to a healthy environment in their state constitutions, and then that kind of petered out. What happened in many of those states was that this was, to some degree, overtaken by events, right? In the sense that this was the very beginning of the whole spate of environmental legislation, and so what courts in many states in the United States said is, well, now that we have all this new legislation, we don't really need to apply the right to a healthy environment, whatever that might mean. There are exceptions, though. Pennsylvania recently has kind of rediscovered their right to a healthy environment as part of efforts to try and limit fracking in that state. I do think it matters how it's drafted. I would never say it doesn't matter at all, but what matters much more is the willingness of courts actually to apply it. The Pennsylvania Constitution is well drafted, but what's more important is that the courts are willing to actually give the thing life. And if the court isn't willing to do that, it can find ways not to enforce it, even if it's really detailed. And that happens in other countries too. I don't want to suggest that every single one of those 100 countries has its courts out there busily enforcing environmental rights. It does not. But it's a lot more than you might think. And the courts that are most active are not always the ones that have the most detailed right to enforce. They're just the ones that are willing to actually hear the cases and go enforce them. Let me give you just one example about that, Costa Rica. Costa Rica in the early 1990s received a handwritten letter from a child, from a youth about environmental problems in Costa Rica. And the Supreme Court of Costa Rica decided that they could have jurisdiction to hear that handwritten complaint about environmental problems, even though it hadn't gone up through the court system, even though the person wasn't represented by a lawyer. It was important enough that they were there to represent, they were there to hear the claim. And of course, that opened the door to Costa Rica hears dozens of cases a year now in its court system applying the right to a healthy environment, even though it's only a one-line right. Some states, I could have gone into more detail about this, India and Pakistan, for example, don't actually have an explicit right to a healthy environment in their constitution. Instead, what the courts in those countries have done is say the right to life includes the right to a healthy environment, and they have extensive environmental constitutional jurisprudence on that basis. I mean, it's kind of amazing from someone from the US to read these constitutional environmental cases. It's like, wow, we have a lot to learn. But again, it's because they're willing to do that.
I've been working with citizens in Flint and Detroit for the last few years now, and folks in Detroit in particular brought the rapporteur for housing and drinking water to the city, and they wrote reports and said that the city was in violation of those. But they didn't use the discourse of environmental justice. They used the discourse of genocide or environmental genocide. And that's not the first time that activists have used that term in the United States. It was in 1991, I think, was the most recent. But the idea is, where the treatment of African Americans in particular, from slavery, Reconstruction, Jim Crow, white flight, and now what's going on in black metropolises is this consistent history. So there's this discourse of genocide. They want to frame what's going on as not environmental justice, environmental genocide. Have you seen that in other places? And does that give them more teeth, for example, in the international circuits?
So really, in the United States, it goes back to the 50s, right? The Genocide Convention was adopted in 1948, actually the day before the Universal Declaration of Human Rights. The Genocide Convention is one day older than the Universal Declaration of Human Rights. The first UN Human Rights Treaty adopted was the one condemning genocide. Some of you may know this history, but essentially the United States, President Eisenhower cut a deal with the Republican senators in the 1950s that in order to convince them to stop pursuing an amendment to the Constitution that would have made it much harder to enter into treaties, he would not bring any human rights treaties to the US Senate. And the concern was largely because the Genocide Convention could be cited, that basically Southern senators were freaked out that what was happening could be described as genocide in some sense. So there's a long history of this. Personally, do I find that it adds more oomph? Not really, honestly. I think genocide is like the worst crime in people's imagination, right? So it's natural to want to use it when you're trying to describe things that are as bad as you can imagine there being. But I personally just don't think it's going to get you anything other than kind of rhetorical power, to whatever extent that is valuable to you. The downside of that is, of course, eventually the word will become something that gets drained of its normal meaning, and there's a real danger for that. I think massive human rights violations are themselves pretty bad. Like, it kind of would make me nervous if we were like, well, that doesn't really get people, that doesn't move the meter. Really, it's got to be genocide. Where do we go when that loses its power? Like, where do we go to next, I think I would be happier feeling like, yeah, let's actually make people respond to the idea that there's massive human rights violations going on,
The original writing by Lennon of the notion of genocide, as you alluded to, was much broader. That there were eight kind of eight fields, right? Political was one. So it was much larger.
Sorry, you're trying.
It has become truncated over time.
Well, it's still pretty broad. I mean, so even Raphael Lemkin's original conception of it was kind of limited to this idea of the destruction of a kind of a coherent cultural group. And the problem with that is a cultural, ethnic, and all the other categories you want to put in. The problem with that is, of course, I mean, it's just really hard to destroy a lot of entire ethnic groups, right? So he also put in language that it was the destruction in whole or part of a group, right? Which makes a lot more sense. The problem is it's often hard to show that part of an ethnic group is being destroyed because of an intent to destroy the group, as opposed to just they have stuff we want or we don't really like them, but you know what I mean? So it's actually, it turns out, international criminal courts that have jurisdiction over genocide cases, it turns out it's actually pretty hard to win those cases. Not that they never get won. But that's another reason I'm kind of concerned about genocide becoming the standard, because to international lawyers, it's really hard to show a case of genocide. And I would like these cases to be easier to be brought, obviously, and not harder. So, yeah.
Yeah. Thank you for your talk. In one of your slides, there was a correlation between the killings, the slide about the 908 killings, and countries where there wasn't a well-developed rule of law or even absent. Now, is there any discussion in the UN of similar incidents of addressing countries where there is rule of law, but environmental activists and scientists who become problematic are persecuted, not in maybe the same way? I mean, especially in the case of Flint, we've been reading about some kinds of issues like that. So that was just one example. But in your deliberations or your presence in these discussions, have you seen sort of a discussion about how to make those visible in places where there are elaborate rules of law, especially also in the case of India? So
Yeah.
if you could just speak to that.
Now that's a really good question, and I kind of used rule of law as a term of art in a way that I should have kind of explained. I meant a rule of law in the sense that the legal system respects human rights. So you can certainly have, I mean, Nazi Germany had rule of law, right? Authoritarian regimes have lots of law. Mother Mushroom in Vietnam was arrested and tried and sentenced all according to the law. So I should have been clearer about that. I do think that part of the problem is, in some cases, even in countries that do have laws, parts of the countries don't seem to have the benefit of the laws that apply elsewhere. And I think that can be true in India, that can be true in places like Brazil, the Philippines, Indonesia. These are places that... Yeah, exactly. So often what happens is that you have a kind of, there's some people in the country have rights and other people don't. I mean, that's something that's obviously been discussed a lot. And so all I meant was that this conflict between extractive industries and governmental supportive extractive industries, the conflict between that and local rights, in a country with a healthy legal system does not have to result in violence, right? You can have the right to protest, you can have free assembly, you can argue against it, all of those things, you can take them to court. It's in countries that don't recognize those rights that conflict gets resolved in violence. Now, having said that, many, many, many more countries fall into that category than I think we like to think. I mean, when I had one of these consultations, it was actually a consultation mainly involving Asian environmentalists and human rights defenders, but there were Europeans there too. And the Europeans started saying, well, actually, now that you mention it, we get harassed and we get arrested, and we're not like exempt from this by any means. And of course, in the United States, we heard about the Dakota Access Pipeline. When you're training a fire hose in freezing temperatures on peaceful protesters, of course, that's a violation of their human rights. And again, that panel discussed this, but the United States has seen a huge upswing in efforts to criminalize essentially peaceful protests. Obviously, it covers more things than just the environment, but a lot of it is focused on the environment. A lot of it is focused on pipeline protests and things like that. And it's just typical of what you see in other authoritarian governments. And I'm sorry I have to use the word other, but what else can we say right now?
One final question in the back.
So rural America is not going to see a lot of these risks like that one map showed. Obviously, you live in like the Lower East Side of New York, you might not be able to live close to the river in like 20 years because it's underwater. But if I go home in like 20 years, my parents probably just be like, it's been a hot summer. And given like the political power of rural America, as it's like shown in the past few years, can America like pass laws and get legislation passed without rural America's like support behind these? And if not, how do you go and convince people that are not going to see any of the risks for like a long time to like get on board with something? It's like easy to see that your jobs are disappearing, but if the environment looks the exact same, it's a hard argument.
Well, I mean, so this kind of goes to the question I asked of the panel before last, like, is there anything to be optimistic about? And so how optimistic I am really varies from day to day. I was asked after one of these talks something like, are you generally optimistic or pessimistic? And I'm like, I'm both. What I'm definitely not is in the middle. Like sometimes I'm like, I'm so inspired by all the people working on these issues and, you know, it's amazing. And other times I'm like, we're all just completely fucked. You know, there's no, I just did that in kind of honor to the lunchtime keynote speaker. I feel like that's what you expect now from your speakers. But so let me give you the optimistic answer, which may sound at first pessimistic, which is rural America is not somehow insulated from the effects of climate change. Rural America is absolutely going to feel the effects of climate change. Let's talk about other areas that we think of as kind of being part of the Republican establishment or just oblivious to what's happening elsewhere in the country. I spent 4 years, I went to college in Houston. I still have lots of friends there. Houston, you know, is still rebuilding. They will be rebuilding for years from Harvey, and by the time, before they're finished rebuilding, the next hurricane is going to hit Houston. So this idea, we are in the United States, especially rich white folks in the United States, are incredibly insulated compared to the rest of the world. The good news, I guess, is that climate change is going to get so bad, we're going to feel, even the richest, you know, insulated white folks are going to be like, this is not a good situation. I live in North Carolina now. We got hit with 2 hurricanes last year that just wiped people out, you know? The hurricanes just wiped people out. So I know someone who's a professor at UNC who's made these films just basically interviewing kind of standard not standard, I don't know what that means, but like, you know, just normal citizens, not academics, not activists, just like, how is climate change affecting you? And they have answers for him. I mean, these are people who are like, I can't go hunt where I used to be able to hunt, or I can't raise bees. I used to be able to raise bees, but now I can't. So the good news is, if you want to think about it that way, is we are all going to be facing such huge problems that it will become harder to deny that they exist. And if we're still intent on not changing our behavior, then I don't know what to say to that. I mean, I guess I'll just say this one last thing. I actually think the problem in this country is not that democracy is somehow against environmental protection. I think the problem in this country is the democratic will of the people is not reflected in our government. So it's not really a failure of human rights or a failure of a kind of rights-based approach in the sense that, you know, people vote for other stuff. They just don't care about environmental protection. I think people absolutely care about environmental protection. It's just that we have a system now that is really stacked against them. So you have to kind of develop super majorities to have the will of the people expressed. So when I think about climate change as a problem, I don't think about it anymore as a technical problem. We can technically fix climate change. Maybe I'm over-optimistic about that, but I just choose to be. Where I'm pessimistic is the political problem. I don't know if we're going to be able to fix the political problem in time to fix the technical problems.
Well, thanks. Thank you so much, John. And in the Netherland between optimism and pessimism, I'd like to thank you all for coming to the Congress and to close the Congress with some thanks to people. I'd like to thank the iSEE directors and the staff who helped make this event run smoothly for everybody. To our director, Evan DeLucia, Madhukana, Jimin Kai, Natalie Koffler, Jenny Kakini, Tony Mancuso, Jordan Gobig, Janet Kurzweil, John Pertl, Meredith Moore, Eric Green, Chloe Rice, and April Wendling. And let's everyone recognize Amy Rosenberry, who, like a lot of the rest of us, has put in a 14-hour day. And she's worked so hard behind the scenes on all the logistics, food, travel, lodging, and all the other accommodations. So thanks so much to Amy. So it's been a terrific day. I hope you take the inspirations and the conversations that you've had in the course of the day with you back home and wherever the places that you work and you dream of a more just and sustainable future for us all. And with that, bid you good nights and good cheer. And look ahead to 2020 iSEE Congress. We don't know what the theme is, but we'll hope you'll join us for that. Thank you very much.